Please state your name and tell us about your background in land use law.
I will. My name is Gene Miller. I am eminently familiar with land use law. Coming from my experience, I was a land use planner for Snohomish County for 18 years. Then I've been a private consultant for 16 years after that. And during that time, I was a planning commission member for 2 terms, 8 years. I have represented both the county and private individuals in numerous occasions in court on legal issues. I actually advised the court on the application of land use law.
Mr. Miller, did you have occasion to review Mr. Weiss's land use case?
I did. In this case, Mr. Weiss owned 2 lots that were given separate tax account status, one of which had a dilapidated structure on it that the city wanted to have demolished. Ultimately, they got a court order for the demolishment of that structure, and subsequently they enforced a lien provision on Mr. Weiss and his property for the collection of the costs for the demolition of the structure and rehabilitation of the site. And in that act, there were 2 specific parcels that the county assessor had segregated out and had actually sent tax statements on for a long period of time. The city initially put their lien on the 1 parcel that did have the structure, but later put the lien on both and took an unusual action of asking the county assessor to recombine these properties. Subsequent to that request and the refiling of the lien, Mr. Weiss went to court to have the property resegregated, or at least to the degree that the lien wouldn't be enforced on both parcels.
I see. And did you have an opinion regarding the legitimacy and the legality of the county assessor placing the lien on 2 parcels? I guess what she tried to do was rescind the subdivision. Is that correct?
That's one way of looking at it, yes, and I think that it's important that we do look at it that way, because again, there were acknowledged 2 parcels, both by the county and by the city throughout this proceeding, until the city actually asked the assessor to combine the 2. And my opinion on that is that that essentially, there's a number of things that I think are unfair about it. I think Mr. Weiss ultimately gets screwed in as much as he is subject to a lien on property that was not subject to the original order of the court to demolish and or the city's order to rehabilitate the property. And so the city, in effect, expanded the scope of their lien without the benefit of there being any cause.
So they took the property in violation of the law, so far as you know.
I would conclude that. I'm not an attorney, of course, but I am eminently familiar with the law. It was the question of the court in that case, in my review of the case file, that there had been a subdivision violation actuated by Mr. Weiss and his son. However, and therefore the court granted specific relief in the form of a penalty I researched it fairly well and found that the city had no penalty clauses with regard to the subdivision or illegal subdivision of property, if that were even the case, and that the court had gone beyond the limitations, the statutory limitations of the Subdivision Act in enforcing their own penalty provision.
Are you familiar with the case Sinkowitz v. Smith?
I am, which has a similar scenario, except for the fact that there were 5 lots, and in that case they were created by an agreement in the purchase and sale of the property.
So what is your understanding as to how the Court of Appeals panel was able to avoid the controlling Supreme Court precedent in Sinkowitz v. Smith?
They utilize the process known as unpublished decision that is given to the appellate court when a decision wouldn't be used as a precedent in other cases.
And so, in your opinion, did they actually use the unpublished decision as a way of not applying the precedential law of Washington to Mr. Weiss's situation and just doing what they wanted?
I would agree with that statement, and I'd go one step further. It's generally known that appellate court decisions are the final decision, and if you utilize an unpublished decision, there is no precedential value and there's no review for legality.
So they can get away with what they want.
They can get away with what they want, yes.
Thank you.